Beneficiary.
Oh, he done.
What you're about to witness is not just another courtroom spectacle. It's a slow-motion collision between fantasy and reality. This defendant isn't simply confused, and he's not just being difficult. What unfolds across multiple hearings is a pattern of escalating instability, manipulation, and refusal to acknowledge even the most basic facts of reality. We're dealing with a man who believes words can override jurisdiction, that refusing a name makes charges disappear, and that imaginary trusts can shield him from consequences, all while facing some of the most serious allegations a court can hear. Across 4 appearances, judges rotate, patience erodes, and the danger becomes clearer by the minute. What starts as courtroom obstruction turns into a serious public safety discussion involving children, prior allegations, and a defendant who refuses to anchor himself in reality. So ask yourself as you watch this, where does free speech end and dangerous delusion begin? Because by the end of this case, the court answers that question decisively.
Before.
What's his name?
The beneficiary.
Yeah. First name, Mr. Beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking what your name is.
My name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm going to recall him. Bring up somebody else. Put him aside. We'll call him at the end. Sir, is your name the beneficiary, Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I ask the questions here. You give me yes or no answers.
You're asking for my permission to
ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. You.
Really?
Yes, Your Honor.
Really?
It is you that
really?
is Kevin Pollard. Yes, Your Honor.
Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout to get your mind right, Mr. Pollard.
Yes, sir. Can I have the clerk present, please, Your Honor?
Don't get banned.
Please have the clerk present in a Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
All right, Mr. Beneficiary, put you back in timeout. All right, beneficiary. I'm going to give you another chance in front of another magistrate.
This moment may seem funny on the surface, but it's actually a critical courtroom control maneuver. When a judge places someone in timeout, what they're really doing is preserving the integrity of the proceeding. Courts are not debates. They're structured environments where one person speaks at a time, and when someone refuses to follow that structure, the judge has a duty to shut it down. Notice something important here. The magistrate never raises his voice. He doesn't argue philosophy, he simply removes the disruption. That's professionalism. And it sends a clear message: you don't get to hijack the courtroom just because you reject reality. Ask yourself, if this is how the defendant behaves at an arraignment, how do you think he behaves when no authority figure is present?
That's no problem. Can I have the clerk present, please?
Hey, sir. Sir, I'm Magistrate Chartea. DDC.
Excuse me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera one, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay. Are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the State of Michigan versus Kevin Theron Anthony Pollard, who
Your
is
Honor,
listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today.
This is the moment the illusion fully collapses. The defendant is now trapped inside his own logic loop, unable to move forward without acknowledging the very identity he's been denying. That's the fatal flaw of these arguments. They don't create freedom, they create paralysis. Legally speaking, a beneficiary has zero relevance in a criminal case. Crimes are committed by people, not trusts, not estates, not legal fiction. And the more he insists otherwise, the more he demonstrates either willful defiance or an inability to understand the proceedings, both of which have serious consequences. Viewers should be asking, at what point does this stop being defiance and start becoming incompetence?
Mr. Pollard,
I'm not.
Mr. Pollard, now as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor.
Ma'am.
Shava Kirk on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. Court dates are February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King. The probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, Mr. Beneficiary, you should not talk over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk. I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct 1st degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot who, the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that the Mr. Pollard touched her, rubbed her, he says, okay? He said, you know, accidentally is what he's trying to tell us what happened. The situation is she's told, the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 1023-2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS tether if he's ever be able to post bond.
This is where the tone shifts from chaotic to chilling. The prosecution isn't speculating, they're laying out a documented pattern involving minors, online grooming, interstate contact, and prior arrests. Bond isn't about punishment, it's about risk of flight, risk of reoffending, risk to the community. When prosecutors ask for high cash bonds, they're signaling that supervision alone isn't enough. And given the defendant's behavior in court, refusing identity, resisting authority, the concern becomes obvious. Ask yourself, if someone won't follow rules in front of a judge, will they follow them on the street?
Counsel Kirkland, go ahead, Esteban, please.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not sexually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed. They were dismissed without prejudice. Okay. This court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th. January 29th, 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr.
This ruling is textbook judicial balancing. The court acknowledges the seriousness, imposes strict conditions, and sets a bond designed to limit access, not just freedom. GPS tether, home arrest, no minors. But notice something important. The judge is still giving the defendant due process. This isn't emotional, it's methodical. And yet, even now, the defendant refuses to comply verbally, reinforcing the very concerns driving the bond decision.
Pollard okay, I'm sorry, the beneficiary, okay, that he is a creditor in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConigal. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pre-trial, Your
Do you
Honor.
wish
No, I wish to
talk
speak to the
to
clerk.
the gentleman
Judge,
that's in
wait,
front of the
just-
screen?
Judge.
Okay.
Pre-trial and
Just so
examination.
for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not
concludes his
fair.
arraignment. Thank
That
you.
is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you can go. Go ahead and do whatever.
You can
This hearing flips expectations. Yes, the bond is unaffordable, but instead of lowering it, the judge raises it. Why? Because affordability doesn't matter if danger remains. Courts aren't required to make bond reachable, they're required to protect the public. The pattern of behavior, the age dynamics, the repeated allegations, they compound. And now the court decides containment outweighs convenience.
Dates?
February 2nd, February 8th.
February 2nd, February 8th, bond
as the clerk
redetermination Monday.
administrator of this SUV trust account that
Huh? What
What is the bond for your client? $250.
Cash, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. You know, obviously, you know, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
You know, Your Honor. And he does a lawn care service, so he does have some work that he does. But the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high part, some type of 10% bond. I think 250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of. This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation Mr. Reagan is talking about the defendant involved in right now with selling and furnishing alcohol to minors, to 12-year-old and 14-year-old. Actually, originally is a criminal civil conduct first degree where the defendant allegedly was having sex with the 12-year-old. Based on apparently idea that someone at hearing it was used to the selling and furnishing the alcohol. So he had an ongoing matter right now, Judge. He's a bond. This particular matter, allegedly, where this individual ended up touching a 6-year-old vagina. We have corroboration to that, and with all due respect, the way that the see this defendant previously in charge, now been charged with another CSE first degree. We find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old. And just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the $250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he.
See, where we haven't heard the arguments of counsel, where this gets a little dicey for concerning bond, is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old who she's in a relationship with for 3 years. So I guess he was 34, starting the relationship with the 15-year-old. Allegedly, she goes to a friend, and they come over, and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts her and asking who is this guy, because her daughter says he touched her vagina. So, and we have another case of furnishing alcohol to 12-year-old.
This is the hammer. $1 million cash bond isn't symbolic, it's incapacitating. The judge makes it clear, even $250,000 wasn't enough to mitigate risk. This isn't about punishment, it's about prevention. And pay attention to the language, danger to all kids. That's not hyperbole. That's a judicial finding based on presented evidence. Whether you agree or not, this is the court drawing a hard line.
And whether there's sex there or not sex there, we have a pattern that's a little bit concerned. A lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of people who are kids and teenagers, and so we're real concerned about this. So, $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable. But it's not enough. It's not enough. So what we're going to do is we're going to add something to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million. It'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. And Mr. Pollard is not to have any interactions with anyone under the age of 18. Whether they're family, whether he knows them, he's not to be around anyone under the age of 18. If he is, that will violate this bond. Thank you.
So, Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash.
Okay.
It's $1 million now. It's $1 million now.
Okay, because he's on Social Security disability now. Can't afford
I understand, but the court finds that Mr. Pollard, maybe some serious action is going on right here. I don't really know if he's like a serious rapist. I don't know if the other children that he lays in the bed and touches, or there's other 12-year-olds, or if he's another 18-year-olds out to break their birthday. So what we got to do is we have to go on the side of call, make sure that Mr. Able at least right now be able to, or even be with engaging in these type of activities.
Judge, I know it's rough when the are from January of 2000, prosecutor doesn't charge until January 20. I mean,
it's like it wasn't until October 14th of 23, the mother called asking, "Who is this cat guy?" We just kind of got that information, and I'm not sure when the 12-year-old, I'm not sure the 12 and the alcohol when that happened. So it's a lot making it. So the time may get a little, but it's kids, teenagers, alcohol, sex, molestation. It's kind of blended, and so we're here where we are.
Yes, sir.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drink for the People, P number 60249. I'm standing in for the Attorney of Record, Assistant Prosecuting Attorney Erica Moses.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. My P number is 58961.
All right. What's your pleasure, counsel? Oh, Mr. Pollard, unmute yourself and tell us your name, sir. Mr. Pollard, have them unmute you so you can tell us your name. Tell me your name, sir.
I exercise my right to remain silent.
You don't want to tell us your name?
I'm the beneficiary.
Beneficiary of what?
Of the trust that we are now here to administrate.
Okay, that's fine. Can you tell me your name?
Excuse me?
Can you tell me your name?
The beneficiary of the trust, Your Honor. I'm not
Beneficiary of trust?
I'm not here, I'm not coming here as the name, I'm summoned as the trust. It'll be a contradiction.
I'm looking for Kevin Pollard. If he's not here, I will capious him.
Your Honor, you are appearing as Kevin Pollard today.
No, I'm not. My name is Kenneth King.
No, Your Honor, you are the trustee of the administrate, the trust that we are now here to administrate. It is a
I have no idea what you're talking about, sir. I'm just looking for Kevin Pollard. If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
Under trust law, it's a contradiction for one to be the beneficiary and the trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about. Miss James, how would you like to proceed?
Judge, originally I was going to ask you to be set for a preliminary examination, but it sounds like it may be a competency issue. So, Judge, what I'm going to ask the court to do, I have an appointment to meet with Mr. Pollard this afternoon. I'm going to ask the court if you would, we can set an exam date, but we could also set Monday as a review date.
Okay, why don't we just do that before we set an exam date?
Okay.
The court will adjourn the probable cause conference. If you're able to find Mr. Pollard.
This case is a stark reminder that courtroom theatrics don't override evidence and fantasy doesn't defeat jurisdiction. Across multiple appearances, judges showed restraint, adaptability, and ultimately firmness when public safety demanded it. The defendant's refusal to engage with reality didn't grant him power, it stripped him of credibility. At the end of the day, the system worked exactly as designed, escalating control when cooperation failed, prioritizing victims, and protecting the community. Backhand index pointing right if you found this case as disturbing and eye-opening as we did. Hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Justice deserves witnesses, and so does the truth.